Good afternoon, everyone. Thank you for joining us for this online webinar on the topic of service and disclosure of telephone evidence in criminal proceedings. Myself and my colleague Jerry Hayes will be presenting this webinar to you this afternoon. Before I hand over to Jerry, who I'm sure needs no introduction, just a couple of housekeeping matters for you. First of all, although you can hopefully see and hear me, nobody can see or hear any of you. You will only be able to see whoever is speaking, so myself or Jerry. Secondly, we have a question and answer function on the screen. Please feel free to type a question if anything occurs to you during the presentation in there, and we will deal with questions and answers at the end, provided there's time and provided we're able to assist. We'll do our best. Finally, this webinar will be recorded and will be uploaded to the Chamber's YouTube channel in due course. And my understanding is that Chambers will email anybody that's registered to let them know when the video has been uploaded, and also will provide you with copies of our slides. There's no need to proactively contact Chambers asking for them. They'll be sent out to you. I'm going to hand over then to Jerry to start the presentation. Jerry, you need to unmute.
There we go. You can hear me now. Yep. Welcome to another Goldsmiths Chambers webinar. What we're going to try and do this afternoon is I'm going to explain, or do my best to explain, what the law pre-Liam Allen on disclosure of social media and telephone evidence is, and then after it, and what the law is now. And what Marie's going to do is explain how we can persuade the prosecution to get what we actually want. Now, could we have the first slide? Right. Now, this basically says the obvious. Social media is really, really, really important. What's on your telephone is really, really important. It is an important and vital source of potential information which can convict the client or get him acquitted. Can we go to the elephant? The elephant. The elephant in the room, except we couldn't find a room, we could only find an elephant. Look, disclosure of evidence has always been a problem, but we've come a very long way since the 1970s when I started practicing. It was like Life on Mars, you know, that television program, because defendants were held incognito, sometimes for days. They wouldn't tell the family, they certainly wouldn't tell solicitors where they were, and they were there and they were on their own. Very often confessions were beaten out of them. In the West Midlands, there was a famous, what was it, the Justice Bunny. And this was a police officer who dressed up in a white bunny outfit, knocked the hell out of the defendant to get a confession. And when the defendant says, well, it was knocked out of me by a police officer in a bunny outfit, no one believed it. That used to happen. Then there was the contemporaneous note. The contemporaneous note was the forerunner to the police interview. Of course, they weren't recorded in any way whatsoever. What used to happen was there would be a, sorry, my phone is ringing, I'll throw it on the floor. What used to happen is the police officer used to write out contemporaneously everything that the defendant was meant to have said. It was in perfect writing. There were no spelling mistakes at all. And of course, a lot of the time, it was totally fabricated. Now, all this changed with the Police and Criminal Evidence Act and eventually the CPIA in 1996, but there were still problems with the disclosure of evidence. And all of us will remember the battles that we used to have in the middle of long conspiracies where there was a lot of telephone evidence which will be disclosed pretty late, where we would just say, please, can you give us some of the raw material so we can get provenance for this? So we can say, well, look, actually, my guy wasn't where you said he was because you're giving us information about pinging off the wrong mast. All of that. It was a complete and utter nightmare. But there was a cultural problem then. There's a bit of a one now. And that's the job of the investigating officer, the officer in charge of the case, used to think that my job is really just to provide the evidence, the information for the prosecution case, that all reasonable lines of inquiry should be purely reasonable for the prosecution. That had to change. And in sexual offences, particularly rape, more often than not, mobile phones were not seized at all, let alone interrogated to gather information which could help actually the prosecution as well as the defence, but very often the defence. This had to change. Could we now go over to the next slide, which is a nice picture of Liam Allen. There's Liam Allen, just had a little girl in February, little baby girl. Now, he was a man of good character with an accusation of multiple rapes against the same girl. And it was one of those Friday night cases which landed on my desk that I had to prepare for trial on Monday morning. Now, on Monday morning, the defence counsel said, look, I know you're new to this case, but apart from the downloads we've got of social media and text evidence, is there anything else that needs to be disclosed? Do you know of anything else? So I checked with the CPS. Well, they couldn't find anything. There was nothing, which is usually where the clue is. There was nothing on the unused, nothing at all. So I went and asked the police officer. Said, right, come on then. Have you got any downloads? Oh, yes, sir. Yes, we have. But of course, we can't disclose them. It's all very private. I said, yeah, but this is a rape, you know. Have you looked at them all? And these are three killer questions that every prosecutor should ask. One, have you looked at it all? Yes, sir. And the most important question now is there anything there which is capable of undermining the prosecution case and assisting the defence? No, sir. Look, I hadn't seen it. CPS hadn't seen it. Defence certainly hadn't seen it. The most sensible thing to do and the fairest thing to do is, if in doubt, disclose. You can sort out the admissibility, you can sort out the weight with the judge in legal argument later, but it's a sort of thing that has to be disclosed. And, well, we did. And when we did, we discovered information which undermined the prosecution case, assisted the defence, and it meant that there was no realistic prospect of conviction. And that was the end of that case. But all hell was let loose. It had blown wide open the argument that we all knew about, that disclosure in this country not only was a mess, but unfair, that there were miscarriages of justice that had taken place and nobody knew anything about. So what happened was we had some changes. But first, let's have a look at the CPIA first of all. That's the next slide. CPIA, you can see those there. It's all set out. The Attorney General's guideline, which I'll deal with a little bit later. CPED's guidance, we can deal with a little bit later. Consent form for complainants, well, it's pretty obvious why that has to be done. There's nothing unusual about consent form for complainants. It was the practice that always happened before, but it was never put in writing. It's in everyone's interests that is done. There may be questions on that, but let's have a look at the 3 R's: retrieve, retain, report. That's something which should be banged into the head of every single police officer at training school. But people seem to have forgotten that the CPIA was set up way back in 1996 to ensure fair and relevant disclosure to the defence, that there had to be an independent disclosure officer. The function of investigators is to look at the case in the round and disclose information that is capable of undermining the prosecution case and assisting the defence. That all reasonable lines of inquiry should be investigated. But unfortunately, old habits remain. Not just the spirit of the law, but the letter of the law was constantly ignored. Cultural and now funding problems. Well, we've had funding problems in the criminal justice system for a very long time now, as we know, because of COVID-19. It is a disaster, but that's another argument for another time. They still, this is the investigation office, thought, even after the CPIA, their job was to build the prosecution case and nothing else. Now, in 1996, emails really didn't exist, nor did the web, nor did social media, and mobile phones were just becoming popular with the general public. And nobody realized that this was going to be a rich source of evidential material in the future. And no one thought that it would require manpower, it would require resources, that it would require technology. Now let's have the next slide, which is the Attorney General's guidelines. I thought I'd put this in because, oh, hang on. You got it? Oh, because it's not on mine. All right, never mind. There's a child with a gavel, but it hasn't come up on my screen. Oh, okay. Right. Thinking and not box ticking. Post Liam Allen, the government offered a review of the way evidence should be disclosed. And the guidelines are very clear. The CPIA should be operated in a thinking manner. That investigators should not only look at whether evidence is capable of undermining the prosecution case or assisting the defense, but to take into account its capacity to support submissions for the exclusion of evidence or stay proceedings. I don't think people have really thought about that sensibly before, that all reasonable lines of inquiry should be followed, that this was not a box ticking exercise. And investigators must disclose significant information that might affect a bail decision. How often do we get that, you might ask? So now, now we've got the judge and the gavel. What are we entitled to ask for? There is a great deal of misunderstanding, myths, and sometimes downright misinformation about what can and cannot be disclosed to the defence in relation to telephones and social media. Now, the most important case, and I just encourage everyone at some stage to read it, it really is worth reading, sets out the rules, the principles, whereby we can get information, get the evidence, get the raw material on social media and telephone downloads. And it's the case, if we could have the next slide, it's the case of R and E 2080, WCA 2426 Chrome. It's a strong bench. It's Leveson, Phillips, and Saunders. And it's not going to be too long, but I've really got to put this case into context so that everyone understands why things were said in the way that they were said. Firstly, what the Court of Appeal had to decide was whether the trial judge was correct to stay proceedings in a sexual assault case where one of the defendant's phones was seized and downloaded, revealing recent complaints, whereas the other wasn't. And the defence argued that the police were in breach of their statutory duty as seizure was a reasonable line of inquiry. It was conceded by the prosecution that there was a snapshot of a text from this phone, which was about the time of the incident, although didn't refer to it, and that phone should have been seized. But it was too late, and all the potentially relevant data had been lost. The judge ruled, this is the judge at first instance, that there couldn't have been a fair trial. Quote, for the majority of younger persons, the phone download is tantamount to a running commentary upon their day-to-day lives, their feelings, their interaction. This evidence goes to the heart of the defense ability to cross-examine a complainant upon a record of their own making. The absence of such material deprives the trial process as a whole because it may be relevant to the prosecution case too, of likely very important contemporaneous evidence. Now, Leveson allowed the appeal from the Crown on the basis that the ruling wasn't reasonable, and you'll see why now. He said, the effect of the ruling was that in every case of this type, in relation to those who communicate through their mobile phones and social media on the basis that it goes to the heart of cross-examination. But the court accepted that, quote, in some cases, it may be necessary for the whole of the download to be examined. The extent of any investigation of digital material should only be confined if it's not considered to be a reasonable line of inquiry. The general approach, he went on to say, is to look at whether the trial will be fair generally, and that requires a consideration of all the circumstances of the case. It is a fact-sensitive decision. So where does it leave us? There is not an automatic right to disclose everything found on a phone or social media, nor is it forbidden. It is, the question is it a reasonable line of inquiry? Next question, is it capable of undermining the prosecution case or assist the defense? And then, probably most important of all, will non-disclosure lead to an unfair trial? Those are the principles of REE. They're very sensible, and it's very important that you have that case handy in case some judges don't appreciate it, or if they do, ignore it. Marie, your turn.
Thank you, Jerry. Right, to start with then, this first slide is practical considerations really, just outlining different procedures or the crossover in procedure between disclosure and service of evidence. Often the disclosure and or service of a telephone download is treated as one and the same thing. We know, certainly for the billing purposes, that it is not the same thing, and drawing a distinction between those two types of disclosure to the defence is very important for us, and dare I say it, the Crown is well aware of that fact also. But just in terms of the stages at which you can start to request this material, both disclosure and service, you see I've put early engagement with the police and or the CPS in writing. This can be as early as charge. In fact, so far as disclosure is concerned, it can be as early as pre-charge. If you're aware of something that needs to be looked into and you want to make sure that the officer in the case is alive to it, you can raise it before they've even been charged, particularly if you think it might mean that your client ultimately doesn't get charged. But then once the proceedings are live, of course, at stage one, the prosecution is going to serve their case, and you'll then find out whether they've served the relevant telephone material in full on you or not. And likewise, with disclosure at stage one, you're going to see the schedule of unused material. Have they disclosed telephone evidence to you as unused material? If they haven't, but a telephone download has been obtained, it should at least appear on the MG6C schedule of unused material. If the officer has got it and doesn't consider that it's relevant to the case, it still needs to be on that schedule. Throughout the proceedings, of course, the prosecution may serve various NAEs, and so any additional notices of evidence will potentially be used to serve a disc or a phone download on you. So far as disclosure is concerned, you need to get to stage 3 before you can start really kicking up a fuss. Secondary disclosure, which will follow your defence statement. So if they haven't provided it at stage 1, you put it in your defence case statement that you anticipate that the phone download should be disclosed, and then you'll see what they'll say at stage 3. And if they say no, then at stage 4 you make your section 8 application. On the other side of the slide, with service, they haven't served at stage 1, there have been NAEs, they're still not serving it. I would recommend that you keep writing to the CPS, highlighting to them that you think this needs to be served, but if that's not getting you anywhere, then you can make an application for a direction from the court under the court's case management powers, specifically CPR 3.5. The court has the power to direct service of evidence. I mentioned disclosure management documents in the disclosure section. Disclosure management documents, we're seeing them more and more now. They are a useful tool to engage with, particularly if you have concerns that the OIC may not fully appreciate the lines of inquiry that ought to be being pursued. The defence are more than expected, in fact, to engage with that process, but it does give you the opportunity to contribute and shape the direction that an investigation goes in, particularly when it comes to electronic material, not simply mobile phones, laptops, bank statements, whatever is relevant, but of course the topic for this talk is telephone evidence. And finally, an abuse of a process or an application to exclude under section 78. If you're doing everything you can and the prosecution are not playing ball, there's always that power available to you. If the court has ordered the prosecution to serve something or to disclose something and the CPS have simply refused to do so, well, it's clear that you would then be looking at seeing if you have the case stayed or excluding the relevant evidence that they seek to rely on. But let's move to service of telephone evidence, and I know that this is of a particular importance to litigators, but you'll see that I put there it's not just about LGFS. It is about page count. Let's face it. It's difficult times, and when we have to consider significant volumes of evidence, we should be remunerated for doing so. But this isn't a game between the prosecution and the defence to see if the prosecution can limit the amount of money you get paid for preparing a case and for defending your client. Likewise, it's not a game for the defence to try to simply increase the amount of pages that they have available to them, nor, in fact, have I ever seen any suggestion that that's the practice of defence solicitors. What it is about is making sure that you get properly remunerated for the work that you are required to do. And the requirement comes, of course, from your duty to your clients to ensure that they have a fair trial. Common issues when it comes to evidence that's actually relied upon by the prosecution as opposed to lines of inquiry that ought to be considered in terms of disclosure. Maybe police officers serving schedules of evidence, summarising contact, for example, between one defendant and a co-defendant on their mobile phones through call data. They may present the most beautifully colour-coded schedules, but the only way you can confirm that that schedule is accurate is if you've been given the raw data from which it's been taken. And that has to be considered, because if those schedules are wrong, it's your job as the defence to ensure that false or misleading evidence isn't put before the jury upon which your client might be convicted. Likewise, extracts, communications between a complainant and a defendant in a rape case, for example, but not simply rape cases, where there have been some conversations that indicate the complainant isn't interested, but later on down the line there are further messages that are very clear indications that she's changed her mind. That's certainly an example of a case that I dealt with in the last few years, where a complainant made some comments but continued to have contact with my client, and indeed then paid for the taxi for him to come and visit her one night and have drinks, and ultimately they ended up having consensual sex, so found the jury. But if the prosecution only serves the messages that assist their case, you need to see the rest of the messages to ensure that there isn't anything else there that shows that there was a change of heart, for example. Or you need to consider the context in which things are being sent. They could have been a joke, for example. Not necessarily that example, but in other cases they may not have been intended to be taken seriously. And then expert reports. Prosecution might want to rely on cell site evidence, and they serve their own expert. That expert has considered raw data. That raw data needs to be served on on you so that you can consider whether to instruct your own experts. So this isn't simply a case of, well, let's just see how much material we can obtain. There are legitimate and important reasons for this to be at the forefront of your mind whenever you're dealing with a case involving telephone evidence. I've also referred to the overriding objective in case management. Of course, we could all play hardball. We could refuse to engage with admissions, for example, that will make the presentation of the evidence far easier for the prosecution, far easier for the jury to digest. If we don't have the raw data, we cannot agree that that schedule is accurate. So we're going to make the officer in the case prove it. We could do that, but we are all required to work together. The overriding objective is a requirement upon all of us, but you cannot do that if you haven't been given the material that assists you to be able to do it. In terms of the argument then, where you've hit a brick wall, you're not getting the material served on you, I'm going to take you through 3 key cases. There are other cases, of course, but these are, in my view, the 3 essential cases for any argument in terms of the service of a mobile phone download or other material. The first, of course, is Boardman, you can see, and the next 2, Lord Chancellor against Edward Hayes and Lord Chancellor and SVS solicitors, they are both costs cases. But as I said, this is not just a costs argument. This is an essential argument about ensuring that we are able to protect the right of our clients to a fair trial. Boardman then, this case was one where the prosecution did in fact serve the evidence, the telephone evidence, and they served it as used evidence, but they did so very late in the proceedings. They had been repeatedly asked in writing by the defence to provide it, and hadn't responded until I think there was a change in prosecution counsel and things started to get moving, as sometimes happens with cases. But by the time material was provided to the defence, it was now too late for the defence to be able to instruct their own cell site experts in advance of the trial. And so an application was made for the trial to be put back. To allow that to be done. What the Crown Court judge did was that he excluded the telephone evidence. He said, no, I'm not adjourning this trial for another 8 months. The Crown should have served this evidence. They failed to do so. It's central to the prosecution case. It was obvious that it ought to have been served. It wasn't. Why should the defendant be further prejudiced by having to wait a further 8 months before he can have his trial? That amounted to a terminatory ruling because it was so crucial to the prosecution case, and the prosecution took the case to the Court of Appeal. And in the Court of Appeal, it came before Leveson, who has a particular interest, as we all know, in the efficiency of the criminal justice system, and he upheld the circuit judge's decision. He made it very clear that where there are delays in the service of evidence, if that's going to have an impact on the trial, it's perfectly proper for the Crown Court judge to exclude that evidence. However, he did also pay some attention to the actions of the defence, and moving forward, it's certainly not advisable to stay quiet. Right to the prosecution, but not bring it to the court's attention. That's not going to fly, essentially, because he said that it would be perfectly open to the court to reject a complaint of prejudice to the defendant if the defence fails to bring the faults of the prosecution to the attention of the court in a timely manner. There had been a lot of opportunity here for the court to address the failing at a time before there was a need to adjourn the trial. And to some extent, the defence had contributed towards that, although the fault did lie with the prosecution. And as a result of that case, we then have the Criminal Practice Direction Amendment last year, which incorporates Boardman, makes it very clear that the Crown Court is able and is perfectly legitimate to exclude evidence if it hasn't been served in time. But again, this issue about have you drawn that fault promptly and explicitly to the attention of the court? And I've put that down there in 24C.13, and it refers back, of course, to the collective responsibility on participants in terms of furthering the overriding objective. Next case then, Lord Chancellor and Edward Hayes. Now, this case and the next case both involve the legal aid agency taking an approach to the service of mobile telephone evidence and insisting that because the prosecution had served extracts of what they considered to be central to their case, those extracts were the evidence, and the wider material, the raw data, the full download, was not evidence when considering the calculation of PPE. And in both of these cases, the court said that's not quite right. This case then, it really highlights 2 points, and those are the points that I mentioned earlier, that first of all, the defence needs to check the accuracy of the extracted data. So the raw data needs to be provided because it's the foundation of the extract. But going further, it has to be viewed in its context. It's not simply a question of checking that the prosecution schedule is correct. It has to be viewed in its context. And I've mentioned paragraphs 12, 20 and 24 there. Please, I'm sure if you don't have a copy of this case already, it's something you should have in your arsenal. But those are the 3 paragraphs that I refer to and that are of particular interest, that highlight the fact that the defence duty goes further than simply confirming that an extract is correct. It's part of the defence duty in representing the client to consider the wider context of the material and also to look at whether there's material that does undermine the prosecution case, in the same way that in a witness statement that is served, for example, the witness says they witnessed the assault, but they also say that they had 7 pints, it was raining, and there was no street lighting in the middle of a December evening. That the prosecution has to serve the entirety of that witness statement. It's all part of the evidence in the case. Simply because it doesn't support the conclusion that the prosecution wished the jury to draw does not mean that it isn't evidence. And moving on to the next slide, Lord Chancellor and SVS solicitors. I refer to this case as the filing cabinet case. It's been my experience that with this case, the prosecution often try to use this to suggest that it is acceptable to serve to serve only limited portions of a telephone download. For example, well, we're only going to give you the messages between the defendant and his co-defendant, or we're only going to give you the text messages between the complainant and the defendant. We're not going to give you anything else because that would be like giving you some of the irrelevant files from a filing cabinet. That is not what this case says, and if that's the approach the prosecution take with you, I suggest you give them a copy of the ruling itself and direct them specifically to paragraph 46. Because what this case is saying is that there may be situations where there is material on a phone download that is clearly of no relevance. And the example that's given here is the user of the phone only uses this one particular platform, maybe WhatsApp, or sorry, I've got a frog in my throat. Only uses one particular platform and only to communicate with their children. No drug dealing messages, nothing else, just communicating with their children, and the communications with the children is clearly not relevant. Well, if that's the case, then fine, don't serve that particular file out of the filing cabinet. But the ruling goes on that those situations will not arise very often, because even in that example, fairness may demand that the whole of the data be served. For example, in order to enable the defence to see what other use the defendant was making of his phone around the times of calls which are important to the prosecution case. If it's being suggested that the phone is being used to arrange the burglary or a conspiracy to burgle, but at the same time the defendant is using the phone to message his friends to arrange a birthday party at the same time as the alleged burglary, that would clearly be relevant. You can't simply look at the messages between this person and this person if around the same time as those messages the defendant is sending other messages which suggest that perhaps something else is going on here. If you don't look at those messages, how are you supposed to know? And also, this case again confirms the role of the defence lawyer is not simply to compare the schedule with the raw data. It also has to check that anything that's been left out to ensure that the presentation of the evidence is fair. So those three cases, I recommend, of course, that you look at them and use them at how you see fit. But yesterday, helpfully or unhelpfully, the Information Commissioner's Office released a report into their investigation of the use of mobile phone evidence in the criminal justice system, more specifically by the police. So in preparing this presentation for you, I had to go away and do some additional research at last minute. And so it has borne this slide, what changes might we see in the future. I've also included the Attorney General's review there, which followed the cases that Jerry was talking about earlier. And I've highlighted a few things that I think may be affecting us in the future. So the Attorney General's review, a couple of things that I pulled out there. This isn't exhaustive, there are other things that were recommended. The introduction of a rebuttable presumption in favour of disclosure of certain documents. I should add that, of course, this review was conducted a few years ago and this hasn't happened yet, but it's still, I believe, in train. What that suggestion was that almost always when you draft a defence case statement, you're going to ask for the crime investigation log, you're going to ask for the 999 call, you're going to ask for any details of previous complaints made by the complainant or different accounts given by the complainant, that sort of thing. Well, given that they're always being asked for and they're always being disclosed, why aren't they just disclosed in the first place? Why are we waiting for secondary disclosure? There should be a rebuttable presumption that unless there's a good reason not to disclose those documents, they should just be provided as of the norm. Greater use of disclosure management documents, well, we're certainly seeing that. And then the use of predictive coding and artificial intelligence. Well, there was a very interesting factoid in this review, which was in 2018 at the time of writing. The average mobile telephone was capable of storing sufficient data to run, I think, 5 million pages of A4. Now you can imagine if you're allowed to claim that much in a PPE claim, you might be onto something. But that's the amount of data that could potentially be on a mobile phone. Clearly, when downloads are being done, there may be just far too much data for officers to be able to go through. And the use of artificial intelligence and coding may be one way to start managing data more appropriately. But the Information Commissioner's report then perhaps has a very different flavour to it. If the Attorney General's review was a concern that there wasn't enough disclosure, the ITO report, I'd suggest, is thinking that there's too much disclosure, or maybe not too much disclosure, but that the police are obtaining too much information in the first place and raising concerns as to what happens with that information once they've obtained it. That said, there is still some reference to, of course, the right to a fair trial, which is an absolute right. The right to privacy is not so absolute, and if there is a conflict between the two, the right to the fair trial seems to me needs to win out. But there is some concern that perhaps the police are asking for things they simply don't need. They are doing full downloads, getting everything, when actually they could be more blinkered in their approach. Perhaps they could be more focused, and there's no need to look at how often a complainant has been using Uber, for example, if that's not relevant to the case. But also I think what we're going to find is that there will be a greater awareness at the police level of the data protection rules. And what is likely to happen is the prosecution are going to start refusing to give us material on data protection grounds. And I have I've pulled out these two cases, in fact, from the Information Commissioner's report. These two cases are likely to be of assistance in terms of understanding what the law actually is in terms of data protection. So if you do find that you're faced with that sort of an argument, have a look at those cases and see if they can assist you. There isn't time to go into them now, and there wasn't time at 3 o'clock this morning to read them in full, so I wasn't able to obtain them. However, they are helpfully summarised in the Information Commissioner's report. I'd also really recommend reading it. It sets out the full legislative framework. So if it's something that you feel you've heard about but you're not too hot on what the law actually is, you don't want to be hit with an objection from the prosecution and not be able to address it, read that report and you will be far better prepared. There is some controversy in relation to that report, but in terms of there's certainly a flavour that's being put on it, that the police are making complainants feel that in sexual offences, that if they don't hand over their phone, that the case won't proceed, and therefore they have to give up their right to privacy if they want to get justice for the sexual offences that have been committed against them. That, I think, it's purely my view, purely my comment, but I feel that's a flavour that's being put on the report rather than the conclusion of the report. A quote that I've pulled is that some complainants and witnesses have reported feeling that if they fail to cooperate, that might prejudice the police in pursuing successful prosecution. But in brackets, it says rightly or wrongly. This report is not drawing any conclusions either way, and any suggestion that it is misplaced in my view. Okay, thank you very much. Right, let's see if we've got some questions. I know that we do. First question. I don't know if this is something you're going to cover anyway, but I'd be especially interested in how this all might apply within a private prosecution. Well, I'll answer that perhaps, Jerry, and then if you've got anything to add, you can come in. It's the CPIA applies to any prosecutor, whether that's a private prosecutor, the CPS, the Post Office, HMRC, whoever is bringing a prosecution, the CPIA applies to them. With that in mind, then, if you are involved in a private prosecution, make sure you're aware not only of your duties in terms of disclosure, in terms of pursuing reasonable lines of inquiry, in terms of disclosing material that undermines the prosecution case or assists the defence, but also in terms of data protection, and certainly be looking at the Information Commissioner's report to ensure that you're hot on that. Is there anything, Jerry, that you want to add? And if there is, make sure you unmute yourself.
Yeah, I'm unmuting myself. No, I agree with that entirely. Because hopefully private prosecutions are conducted by professional lawyers, so they know the rules. For example, if they interview somebody, it's got to be by the PACE rules. At a slightly different angle, the difficulty we have at the moment are vigilante groups in relation to paedophiles. They trap people online. And I've been involved in a number of cases where these people, I suppose in their eyes have done a good job for members of the public, but have completely messed up a case. So someone who really is a paedophile and a danger to children, just generally, really get off scot-free. And that, to my mind, is wrong. But yeah, I agree with you on that, Marie.
There's another question from the same person, also on possibly that topic. Let's say that a private organisation was doing a freelance undercover investigation. They used texting and messaging, etc., prior to going into premises to plan. Whilst actually on site, they used texting to coordinate. Is any of this disclosable in future private prosecution, or would that attract some sort of privilege? Well, Jerry, I wonder if it's almost linked to the.
It just depends on the circumstances, doesn't it? If there's been entrapment, got a problem there because we don't have entrapment. As long as people obey the rules, as long as people don't go on frolics of their own and taint the evidence, all well and good. Also, as well, for private prosecution, if my memory is correct, you'll correct me if I'm wrong, Marie, can't the DPP intervene and say, no, you just can't go ahead? Because there's all this talk about Dominic Cummings and there's been crowdfunding for a prosecution. Now, what does the Attorney General do? Well, I know what this Attorney General will do, and she's probably going to get into trouble for it. I hope it doesn't come to that. But you've got to be so careful in private prosecutions. You really have, because what may seem like an absolutely brilliant idea, they may not be people who are doing it who are used to dealing with criminal procedure. Very often there'll be sort of she commercial bunches of solicitors with she commercial barristers. Nothing particularly wrong with that, who may not just get it and then mess it up.
Yeah, thanks, Jay. I suppose on that note, it'd be a good tie-in to remind everybody that our head of chambers last week with our colleague Adam Gersh did a presentation on private prosecutions. Certainly worth a watch if that's something you're interested in, because they aren't of the type of inexperienced criminal practitioners that Jerry mentioned. They know what they're doing, and they're certainly a safe pair of hands. The other thing I would say about that question is that I think the question needs to be examined in a different way. Is it disclosable, or would it attract some sort of privilege? Well, actually, the first question is it disclosable? And if it's disclosable, you then have to look at whether it attracts privilege. And if it does, it then would have to go before a judge, and a judge would make a determination. And that applies whether it's a private prosecution or a CPS prosecution. So I think the two are distinct. It could be disclosable, but if it is privileged, then a judge will make a determination as to whether or not it falls to be disclosed or not. Another question: should the CPS or police be held to account where there is such a clear breach of their duty to disclose? I suppose procedurally, of course, there's the application to stay or exclude evidence, which may amount to a terminatory ruling. And certainly in Boardman, Leveson said at the very end, the CPS owes these complainants an apology. But in terms of public outcry, I suppose Jerry knows more about that than I do. I mean, Jerry, is there anything that you want to add?
Well, yes, wasted costs. If you've been brought to court on something that has been completely messed up by the prosecution authority, either by incompetence, lack of due care, or even a malfeasance, which is usually fairly unlikely, then all that time you spent in court, you should be paid for by the prosecution. That is the deterrent for people to get it right.
Right, one last question at the moment. What advice would you give to solicitors and paralegals who are tasked with going through significant pages of mobile phone evidence? Well, if I deal with that, I suppose the first thing is to make sure you know what it is you're looking for. There's no point just looking at data and hoping to figure out what's going on afterwards. You need to know what the issues are, what's the prosecution case against the client, and also what does the client say about it, because that will inform your approach when you're going through lots and lots of pages. That if something is relevant to that, it will more likely stand out to you. So that's the first thing. The second thing, from a practical point of view, is to keep a record, a work log. If the number of pages goes over, I think it's 10,000, then there'll be a claim for special prep. But if you haven't got a work log to evidence the work that's been done, it's much more difficult. So make sure you keep a work log, and practicalities and for fee purposes, ask to have the material served in Excel format. Often the CPS might provide it in PDF, but it's easier to search in Excel format. And there are a number of cases that have dealt with whether or not how you calculate page count. Some of them have said that you can use the Excel page count rather than PDF. There was, actually, it's interesting that you've asked that question, that's come to mind. There was another case that came out yesterday, and I can have it a copy sent out with the slides. I just try and find, I did make a note of it in case it came up. Shake, I think Shake, dealt with in May, so last month, where the cost judge said that certainly their approach is that the page count should be based on PDF, but rather than Excel. But on the other hand, where there hasn't been service in PDF form, they deal with how you calculate the number of pages, and it seems as though the legal aid agency were trying to say, oh well, this number of A1 sized pages rather than A4, which is just rather obscene if you ask me. But the cost judge was very clear to nip that in the bud. But I will have a copy sent out with the notes, as it may be of assistance to those of you that put in LGFS claims in due course. Are there any other questions? No, we've got a thank you. See if there's anything in the chat. Sometimes people type questions in the chat. Okay. Today I got an email from CPS saying there's no point to them serving the raw data unless I had instructed an expert. What are your suggested responses? Well, the first is that the CPS are not the end of the matter. You can make an application to the court under the CPR. It's not just a case of whether you're serving an expert. It really depends on what evidence they're trying to serve. But for example, if they've got a police officer that's saying, oh, the cell site data says this, we'll serve the cell site data, because how do I know you're right? You're not even an expert. How do I know that the cell site data really does say that? So even from the viewpoint of checking the accuracy of what the prosecution are relying on, they need to serve it. And the other suggested responses are get out your Lord Chancellor versus SVS solicitors and make application and argue it in front of the judge. And then another point. Oh, anything you want to add?
Can I just add to that? This is just from the prosecution point of view, and that is a lot of prosecutions now, when you're dealing with cell site in particular, they will not instruct an expert because it's very, very, very expensive, and sometimes they will instruct a police officer. Now, if he's a very experienced police officer, that's pretty good, but there is authority to say that what you really need to do when it comes to routing, in other words, pinging off various aerials and all the rest of it, and cell site analysis, you really do need an expert. And I had a case fairly recently, and my alarm bells went up when a police officer did some very detailed stuff. It was very professional work, but he didn't actually say what he'd done in the past, which they normally do. And it came forward that from him that actually he wasn't really an expert, but he'd done half a day's training. I mean, obviously he learned an awful lot, but that could have been serious problems for prosecution. As a result, we instructed a more experienced police officer, and so all should be well. But that's something, if you're prosecuting, you've got to be aware of.
Okay, I think that we should probably draw a line there, because we've overrun quite considerably. But thank you for joining us. Thank you for your time. I hope that you have found this webinar useful. If there are any questions that occur to you that we haven't been able to answer, please feel free to contact us via our clerks. Please contact John Francis. Lynn and Mike are not currently working. They're on furlough in the current climate. Hopefully they'll be back with us very, very soon. But thank you again. And as I said at the beginning, this will be uploaded to the Chambers YouTube channel, and the slides will be circulated. If you're watching this live, then we've got your details and they'll be provided to you. If you watch it on YouTube later, please feel free to contact Chambers, and we're more than happy to share the slides with you. Thanks very much. I'm going to end it. Yeah.